Hello everyone, welcome to PW OnlyIAS. And yes, we are here with the continuation of the class of polity chapter on fundamental rights. We are continuing from where we left off in the last class. Before we head on with our class, once again, this is my Telegram channel, people. Any queries that you have, any doubts that you have, please contact me here directly. Apart from that, let's move on now to our continuation. So we had left off at Article 19. So Article 19, we are going to see what other sub aspects are there to Article 19, and we will see here now freedom of residence. Under freedom of residence, what do you have? You have the right to reside and settle in any part of the territory of the country. Anywhere if you want, you can settle. Now this could mean two things. You can settle at any place temporarily, or you can set up your home or reside anywhere permanently. Both are possible, and both these are two parts of the right. It removes the internal barriers within the country or between any of its parts. Simply means we can actually move like freely, you can move anywhere in the territory of India, just like that, temporarily, maybe because of your job, or permanently you can settle down. Generally, if you see with IAS officers or any officers, some of them settle in the city or in the state where they have got their cadre. After 20, 30 years of service, people may feel, I have become so much part of the state now. There is no point in going back to my hometown. I would rather settle here rather than going back to my home state. Some people, what do? Okay, they have served the state for maybe 30 years of their service. Now they would like to have a settled, peaceful life. They want to go back to their home state. So that's the point here. You can do that anywhere in India. Then the Supreme Court basically told certain areas can be banned for certain kinds of persons like prostitutes and habitual offenders. You can put reasonable restrictions for certain categories of people like prostitutes and habitual offenders. That is people who are, who may attack children or attack women. Such people can be restricted from entering a certain area. Say, for example, certain states have the Gunda Act. Once your name comes under the Gunda Act or under the Gunda list, your name features, you're not allowed to enter that district or that city, territory or the municipality area for a certain time period. You're banned from entering that place. Right to residence and right to movement are overlapping to some extent. Overlapping why? Because it almost has the same meaning. Means what? See, I need my first of all, I need the freedom to move anywhere in India. Only when I have that freedom, I'll be able to settle anywhere, either temporarily or permanently. What does that mean? It simply means both these rights are what? They are complementary to each other. Now, as usual, what are the grounds of restriction? The grounds of restrictions are, as again, in the interest of general public, protection of the interest of any scheduled tribe. That is, if you remember, many years ago, Supreme Court has placed restrictions with regard to freedom of movement when it came to the tourism sector in Andaman and Nicobar Islands. A photo came out where tourists sitting in a bus, they were giving some piece of orange or food or something to a female who was identified to be from the Jarawa tribe. Jarawa tribe, it's a very shy tribe they are. They generally, when they see people, any other human being other than their own tribal people, they hide away. This was a rare instance where there was this female from the Jarawa tribe. She was walking, or apparently she was very near to the road where the bus was, and a photo was captured. So Supreme Court intervened also, and Supreme Court basically told that restriction has to be placed because to protect the culture of the Jarawa tribe. So this can be done. Clear, people? Moving on to the next freedom, which is freedom of profession. So profession, again, everybody, as long as you have the requisite skill, etc., you can practice, profess, and even do the job whatever you like. Here again, interesting scenario is there. Now, I told you, in the case of Andhra Pradesh, there is still a qualification category is there with regard to non-gazetted jobs that you have to be from that local area. only then you will get a job. Fine. But can this be kept as a major criteria? Very recently, we know the governments of Karnataka as well as Haryana tried to pass such laws that Group C and Group D level jobs should be reserved only for the localites of that particular state. It was struck down by the Supreme Court. Why? Because it violates this fundamental right. And in Anuradha Basin case 2020, the Supreme Court held that the freedom to practice any profession or carry on any trade, business or occupation over the medium of internet enjoys the constitutional protection under Article 19(1)(g). What does it mean? Even if you are even if you are practicing a profession online, you are protected. You can carry out that particular trade or occupation. The restriction on this right should be in consonance with the mandate under Article 19(6), inclusive of the test of proportionality. Test of proportionality. Test of proportionality simply means it is sought to maintain a balance between constitutionalism and individual freedom. We know that individual freedom is not absolute. In certain cases, restrictions can be placed. So whatever restrictions you are going to place on a person who is doing into a job that is using internet or has a online presence, reasonable restrictions can be placed on it. Further, an order suspending internet services indefinitely is impermissible under the temporary suspension of telecom services, public emergency or public safety rules 2017. So, indefinite suspension of internet services is not what permissible. Why? Again, it will affect the freedom of profession. If I am somebody who is using the internet, let's say I am a social media influencer, my bread and butter basically comes from the revenue that I generate online. So indefinitely, when internet services are suspended, it affects my livelihood. Getting the point here? Taking it further forward. Grounds of restriction in the interest of general public, requirement of necessary professional or technical qualification. That can be a main reason. That is, if you don't have a particular technical qualification or the necessary qualifications for a particular job, then you can be denied the same. Any trade, business, industry or service carried on by the state to the exclusion of citizens, added by the First Amendment Act of 1951. That is, anything can be any particular law with regard to a particular trade, a particular business. It can be made. Reasonable restrictions can be made where citizens cannot access it, or not all citizens can access it. They can give specific details. Only such people may apply for this job. Like that. Taking it further forward. Protection in respect of conviction for offences. Article 20. Protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a corporation. Arbitrary means what? Arbitrary means it is not defined. It is strictly the punishment is given based on the whims and fancies of the officer. That is, if the officer is in a nice mood, he will give less punishment. Officer is in a bad mood, he will give a severe punishment. Classic example of this, you can see it on the road whenever the traffic policeman stops people who are riding without a helmet, etc. Generally, there is a soft attitude towards females. But there is a little more harsh attitude when it comes to males. It is very arbitrary. It is not clearly defined there. It contains 3 provisions in that direction. No ex post facto law. Ex post facto law means I can only be punished as per the law that is in existence today. Getting the point here. Today, is there a law? What is the punishment based on that? That is, today if I am riding the scooter, two-wheeler without a helmet, fine could be 500 rupees. Alright, today's law it is that. That is the law. 10 years ago, I didn't wear helmet. That time the punishment was 100 rupees. So when did I commit the crime? 10 years ago. So the crime that I committed 10 years ago, for that can I be punished with the law that is in existence today? Simply means, in 2014, if I didn't wear a helmet, Can I be made to pay 500 rupees, which is the fine of 2024? No. What law is in existence, for that what is the punishment? That is how the punishment can be given. No person shall be convicted of any offense except for violation of a law in force at the time of the commission of the act. What is the law at that point of time? So today, any crime is being committed. Will the person be tried under Bharatiya Nyaya Sanhita or CRPC? It will be BNS. Why? Already they have come into force. What about a person who committed a crime in 2013 or 2024, January 1? Now it has been proven that this person committed the murder. All right. Murder occurred when? 2024, January 1. Then they will be tried under CRPC. Getting the point here? Because BNS came on a much later date only. From that date, whichever crime henceforth that happens will come under Bharatiya Nyaya Sanhita. Whereas anything before that, if it is proven the crime was committed before the date of occurrence of BNS, then automatically that they will come under the provisions of what? Indian Penal Code, CRPC, etc. All right, people. Moving on. Subjected to a penalty greater than the prescribed by the law in force at the time of the commission of the act. No person shall be subjected to a penalty greater than that prescribed by the law in force at the time of the commission of the act. Means what? Simply means, like I told you, how much is the penalty now? That much only you can ask. Not more, not less. No double jeopardy. No double jeopardy simply means you can only be arrested or only be punished for a crime once. You cannot be punished again and again. Getting the point? No person shall be prosecuted and punished for the same offense more than once. No self-incrimination. No person accused of any offense shall be compelled to be a witness against himself or herself. That is basically, I cannot be forced or you cannot be forced to give a statement against your own self. You have the right to silence. An ex post facto law is one that imposes penalties retrospectively. That is from a back date onwards. If an ex post facto law comes into place, it simply means from a back date onwards, I can impose punishment. Generally, for criminal laws, you don't have what? You don't have ex post facto law. Or in other words, from a back date, you cannot apply a criminal law. But from a back date, you can apply a civil law. The enactment of such a law is prohibited by the first provision of Article 20. Limitation is imposed only on criminal laws, not civil laws. Further, this provision prohibits only conviction or sentence under an ex post facto criminal law and not the trial thereof. So, only the punishment part is where you are saved from, not the trial. Getting the point? Punishment will be based on the current law. That is, the current law may be awarding you a punishment of, let us say, 3 years. Old law may be 2 years. So what is the current law? 3 years is the punishment. That punishment will still apply. Plus, you have committed a crime earlier also. So the trial for that earlier crime, that can happen. Just because the crime had occurred 10 years ago, you cannot say that, no, that crime is old crime. We are not going to carry a trial for it. No. Trial will be there. And for that trial also, punishment will be according to the law that was applicable at that time. Getting the point? Simply means, in a nutshell, what is the final conclusion? When did I commit the crime? At that point, what was the law in effect? That's it. So whether it is today means today's law. 10 years ago I committed a crime means what was the law 10 years ago? Clear, people? The protection under this provision cannot be claimed in case of preventive detention or demanding security from a person. So these things are not applicable when in the case of preventive detention. Protection against double jeopardy is available only in proceedings before a court of law or a judicial tribunal. In other words, it is not available in proceedings before departmental or administrative authorities as they are not of judicial nature. I'll tell you the interesting scenario here. So, one individual who was working with the Kerala Motor Vehicles Department, his wife committed suicide because of dowry harassment. Departmentally, the action taken against that individual was dismissed him from service. Dismissed him completely from service. Number one. But that is the action taken by the department. That is a departmental side action. Legally, his actions have led to suicide of his wife. That punishment is different. If you actually look, it is almost like he's getting punished. He lost his job. Now he will go to jail. He has gone to jail also. All this you may feel. But that is how it is. Departmental level, they can take action and that is not considered to be a judicial decision. That's departmental level. The protection against self-incrimination extends to both oral evidence and documentary evidence. That is, you need not give oral evidence against yourself or submit any documentary evidence against yourself. However, it does not extend to compulsory production of material objects. Court can ask you to produce certain objects there, because only if you produce them, court also can judge to know whether you are innocent or guilty. Compulsion to give thumb impression, specimen signature, blood specimen. That also can be compelled. Compulsory exhibition of the body. So compulsory exhibition of the body, especially in cases of rape, etc., generally when the victims put a fight with their perpetrators, marks will be left on the body. So the cops also can ask you to remove your shirt and show your body. Getting the point? It extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. So all these basically are generally associated only with criminal proceedings and not with those proceedings which are not of criminal nature. Protection of life and personal liberty comes under Article 21. No person shall be deprived of his or her life or personal liberty except according to the procedure established by the law. This right is available to both citizens and non-citizens. What does that mean? That is, if I am going to deny you of your life, it should be based on an accepted procedure. That is, we all know Section 320. Capital punishment is awarded. And then appeal goes to the High Court. From High Court, it will go to the Supreme Court. It is not like how they used to show it in the movies and all. That is, lower court will decide and that's the end of it. No, there are so many procedures behind it. It will go to the High Court, then it will go to the Supreme Court, then it will go for review, then it will go to the President, then from the President again a review will go. So multiple levels it has to clear and pass, and finally the capital punishment occurs. Gopalan case, 1950, the Supreme Court took a narrow interpretation of the Article 21. That is, the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. That is, denial of life is, if it is done through arbitrary government action, okay, we will protect you, but not from arbitrary legislative action. That is, if government passes any law which will take away some person's life, it is okay. That is what initial ruling was, that was given by Supreme Court. State can deprive the right to life and personal liberty of a person based on a law. This is because of the expression procedure established by law in Article 21, which is different from the expression due process of law contained in the American Constitution. What does this mean? Simply means, if life is being taken away of a person, as long as it is by a procedure established by a law passed by the legislature, then it is okay. Even if the law was passed in a very big hurry, without much discussion, debate, hurriedly the law was passed and a person's life is being taken out, it is okay. This was the first ruling. As long as there is a procedure to take away somebody's life, it is okay. That was the ruling. They did not look into the larger context of what? The larger context of due process of law, which is followed by the American Constitution. I already told you what is due process of law. You're not just simply reading the law, you're looking at the big picture. And we did look at the big picture because the change happened. Validity of a law that has prescribed a procedure cannot be questioned on the ground that the law is unreasonable, unfair, or unjust. You cannot question it. This is the stand taken by Supreme Court initially. However, Maneka case, Supreme Court overruled its judgment, taking a wider interpretation of the Article 21. Right to life and personal liberty of a person can be deprived by a law, provided the procedure prescribed by that law is reasonable, fair, just, and not arbitrary, fanciful, or oppressive. That means the Maneka case, if you see, is a hallmark. It's a turning point. Why? It basically brought in the concept of, or rather, it introduced the concept of due process of law. That means not just that the government can do any protection is there against any nonsensical action from the side of the government. Any unreasonable law passed by the parliament, you will be protected against that also. Unreasonable, unjustified law is passed by the parliament in a hurry just to snatch away somebody's life. Today it is not possible. You will be protected against such laws. In order that the procedure is reasonable, fair, and just, the procedure should conform to the principles of natural justice. That is, it should be sensible. That is what it means. Natural justice, when we say, it is ultimately sensible. There should be some sense to it. It is not that just because you are the parliament or legislative assembly, you can simply pass any arbitrary law. Supreme Court, personal liberty means only liberty relating to the person or body of the individual. For that personal liberty, when we say, it's up to the individual's liberty. Moving forward, it has introduced the American expression due process of law, protection under Article 21 available against arbitrary executive action and arbitrary legislative action. This is the current reality. Article 21 is not an animal existence or survival. Right to live with human dignity and all those aspects of life which go to make a man's life meaningful, complete, and worth living. It also ruled that the expression personal liberty in Article 21 is of the widest amplitude and it covers a variety of rights that go to constitute the personal liberties of a man. So Article 21, right to life, when we say, it has been broadened by the Supreme Court through various judgments. Right to a clean environment, right to privacy, etc. Then personal liberty also, it means, it again has taken a very broad view of the meaning of personal liberty. Moving on. What and all comes under Article 21. Go through it multiple times. That is what I would say. Right to live with human dignity. Right to decent environment, including pollution-free water and air and protection against hazardous industries. Right to livelihood, right to privacy, right to shelter, right to health, right to free education up to 14 years of age, right to free legal aid, right against solitary confinement, right to speedy trial, right against handcuffing, right against inhuman treatment. So here, living with human dignity, livelihood, environment, privacy, shelter, health, free education up to 14 years of age. Free legal aid is also part of this. Right against solitary confinement. Right to speedy trial. Right against handcuffing. Right against inhuman treatment. Why I have marked only these? because these you may probably not guess. The others still you can guess. Clear? So free education up to 14 years, free legal aid, right against solitary confinement. That is a punishment. Solitary confinement means locked up all alone inside a cell. You're not allowed to interact with other prisoners. You're not allowed to even step outside. You're locked there, all alone. Right against handcuffing, right to speedy trial, right against inhuman treatment. Clear, people? Moving on. Right against delayed execution, right to travel abroad, right against bonded labor, right against custodial harassment, right to emergency medical aid, that is right to doctor's assistance, right to timely medical treatment in government hospital, right not to be driven out of a state, right to fair trial, right of prisoner to have necessities of life, right of women to be treated with decency and dignity, right against public hanging, right to road in hilly areas. So all these comes under what? Article 21. Right to information, right to reputation, right of appeal from a judgment of conviction, right to family pension, right to social and economic justice and empowerment, right against bar fetters, right to appropriate life insurance policy, right to sleep, right to freedom from noise pollution, right to sustainable development, right to opportunity, right to decent burial or cremation, right to marry a person of one's choice, right to die with dignity, passive euthanasia. All right, people. So go through it multiple times. That is the only way you are going to remember it, because you can get a question from this side. All right. Right to education comes under Article 21A, which talks about free and compulsory education to all children of the age 6 to 14 years. Note the age down, people. In such a manner as the statement determined. Elementary education a fundamental right and not higher or professional education. That is the core idea here. Basic elementary education is a fundamental right. Beyond that, it is left to an individual socio-economic background. It was brought in by the 86th Constitutional Amendment Act of 2002. Basically, the broader idea is what? Education for all. The government described this step as the dawn of the second revolution in the chapter of citizens' rights. Free and compulsory education for children was initially mentioned under Article 45 in Part 4. Amendment changed the subject matter of Article 45. Today it is what? Today it is the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. 6 to 14 is a compulsory right. No, it's a compulsory fundamental right. Nobody can question it. So that is why the nature of Article 45 changed. That is now today it is the state's responsibility to ensure that till the age of 6 years, the primary education, whatever is required, it is provided. New fundamental duty under Article 51A that reads, it shall be the duty of every citizen of India to provide opportunities for education to his child or ward between the age of 6 and 14 years. So, DPSP was what? State's directions for the state. So, for DPSP, as far as education is concerned, state's job is to provide primary level education at least till 6 years. 6 to 14, it is a duty of every citizen. That is, I am a father today. So, automatically, what does it mean? It is my responsibility to ensure that my child gets the basic level education between the ages of 6 and 14. Unnikrishnan case 1993 itself, the Supreme Court recognized a fundamental right to primary education in the right to life under Article 21. That is the most interesting thing here. As early as in 1993, in the Unnikrishnan case, Supreme Court had recognized that education is part of a right to decent life. It held that every child has a right to free education until he or she completes the age of 14 years. In this judgment, the court overruled its earlier judgment delivered in Mohini Jain, wherein it partly declared that there was a fundamental right to education up to any level, including professional education like medicine and engineering. That was the first ruling. But that again, imagine the burden that will come on the state. In pursuance of Article 21A, the Parliament enacted the right of children to free and compulsory education RTE Act 2009, which came into effect from 1st April 2010. Every child has a right to be provided full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. And as any child can get admission to any school today. That is the bottom line. RTE ensures that the child is between 6 to 14 years. No school can deny admission, that saying that the child is from a poor background or something. You have to give admission. Taking it further forward. So, moving on to the next topic now, which is protection against arrest and detention. Taking it further forward. Article 22. Detention is of two types, namely punitive and preventive. Punitive, preventive. Punitive means it is a punishment. You committed a crime, trial happened, everything happened, and afterwards, judge writes or judge finds you guilty, then you get convicted. For that, based on what type of offense it is, you get a punishment. That is punitive detention. That is after the commission of a crime, after the trial, after taking it to a court, you get a punishment. Whereas preventive detention, we'll just go through punitive detention's definition once. Punishment after trial and conviction in a court. What about preventive detention? Preventive detention actually means before the commission of a crime. On mere suspicion, a person can be detained up to a period of 3 months. You don't have to commit any crime. Mere suspicion that you can impact the overall public order or you can affect the overall peace in the area, that is sufficient to arrest a person and detain them. Detention of a person without trial and conviction by a court. Why? To prevent him or her from committing any offense in the near future based on suspicion alone. Article 22 has two parts. The first part of Article 22 confers the following rights on a person who is arrested or detained under an ordinary law. So two parts are there for Article 22. The first part, again, if you see, it basically allows certain protection. Especially when it comes to punitive detention matters, it offers certain protection. And what is the number one? Right to be informed of the grounds of arrest. Why you are being arrested? What is the offense? Where is the arrest warrant? You can ask that. Number two, right to consult and be defended by a legal practitioner. You can always demand for a lawyer. Then, right to be produced before a magistrate within 24 hours excluding the journey time. That means, irrespective of the journey, maybe the magistrate is, let us say, 4 hours away. Very far it is. So will that 4 hours be considered as part of your detention time? No. Your detention time is only the time when you were inside police custody, not while you were traveling. Right to be released after 24 hours unless the magistrate authorizes further detention. That is, police can keep a person in custody up to a period of 24 hours only. Beyond that, if they have to keep a person, they need a magistrate's order. Or it should be what? Straight away preventive detention. These safeguards are not available to an enemy alien or a person arrested or detained under a preventive detention law. So under preventive detention law, you cannot say that I need to see the magistrate. More than 24 hours is over. No. Under preventive detention law, you can be held in police custody for up to 3 months. The Supreme Court also ruled that arrest and detention in the first part of Article 22 do not cover arrest under the orders of a court, civil arrest, arrest on failure to pay the income tax, and deportation of an alien. That means whatever protection we are talking about, that does not follow in the case where arrest is because of what? Order from the civil court. Then it's a civil arrest. Civil cases. Arrest on failure to pay the income tax or deportation of an alien. That is, you are an alien, you are not somebody who is a citizen of the country. It is your deportation. In that sense also, when you are arrested, you cannot demand, okay, show me where is the magistrate, oh, where is the lawyer. You cannot demand any such things. They apply only to an act of a criminal or quasi-criminal nature or some activity prejudicial to public interest. Bottom line is that these laws or these protections are only available in those cases where there is some form of criminal act, either partly or fully. Clear? The second part of Article 22 grants protection to persons who are arrested or detained under a preventive detention law. This protection is available to both citizens as well as aliens and includes the following. Detention of a person cannot exceed 3 months unless an advisory board comprising of High Court judges reports sufficient cause for extended detention. That means if some person is arrested, they can be kept in under preventive detention for a maximum time period of 3 months. Beyond that, if I want to extend it, then you need the recommendations coming from an advisory board comprising of High Court judges. That is the first point. Second, the grounds of detention should be communicated to the detainee except facts against public interest. That means if a person is going to be detained under preventive detention, why is that person being detained there? What is the reason? That needs to be communicated, except if the information that I am communicating to the person can be detrimental to public interest, then it won't be communicated. 3. The detainee should be afforded an opportunity to make a representation against the detention order. That a person should get the opportunity, because otherwise imagine anybody on whom the police have a vengeance, they can easily arrest the person and put them in under preventive detention. Getting the point here. So, in order to avoid that, there should be an opportunity given to the detainee to actually what? To actually put forth their end of the argument. Article 22 also authorizes the Parliament to prescribe A. The circumstances and the classes of cases in which a person can be detained for more than 3 months under the preventive detention law without obtaining the opinion of an advisory board. The maximum period for which a person can be detained in any classes of cases under a preventive detention law. The procedure to be followed by an advisory board in an inquiry. So 3 conditions. Only Parliament can make laws with regard to what? If a person has to be detained for more than 3 months, only Parliament can make law there. The maximum period of preventive detention also only Parliament can decide. Third one, the procedure that has to be followed by the advisory board, that is consisting of the High Court judges, what procedure they have to follow, even that also only Parliament can make laws. The 44th Amendment Act of 1978 reduced the period of detention without obtaining the opinion of an advisory board from 3 to 2 months. So 44th Amendment Act basically tried to reduce 3 to 2 months, and it was successful also. Successful means in the Amendment Act it got passed. Instead of 3 it will be 2, but it has never been implemented. 44th Amendment Act reduced it from 3 to 2, but implementation has not been done. As a result of which, even now, the original period continues, which is what basically 3 months. Constitution. Legislative powers on preventive detention has been divided between the Parliament and state legislature. So when it comes to the time period, advisory jurisdictions, So when it comes to preventive detentions, increasing the time period, or what should be the maximum period, or what should be the procedure for the advisory board, these matters are decided by Parliament and Parliament alone. But preventive detention laws can be passed both by the state as well as the Legislative Assembly. In this particular case, Parliament can pass laws on preventive detention with regard to defense, foreign affairs, and the security of India. Parliament and state legislature can pass laws on security of a state, the maintenance of public order, and the maintenance of supplies and services essential to the communities. Preventive detention laws made by the Parliament are Preventive Detention Act 1950, expired in 1969, Maintenance of Internal Security Act, MISA, 1971, repealed in 1978. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, COFEPOSA, 1974. National Security Act, 1980. Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act, 1980. Terrorist and Disruptive Activities Prevention Act, TADA, 1985, which was repealed in 95. Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act, PITND, PSA, 1988. Prevention of Terrorism Act, POTA, 2002, repealed in 2004. Unlawful Activities Prevention Act, UAPA, 1967, as amended in 2004, 2008, 2012, and 2019. Moving on, right against exploitation. Coming to right against exploitation. Under right against exploitation, we have prohibition of traffic in human beings and forced labor, where Article 23 prohibits traffic in human beings, beggar, and other similar forms of forced labor, that is even bonded labor. So human trafficking, you must understand, human trafficking in a nutshell, its simple meaning is treating human beings like goods. You're not concerned about what they want, what their rights are, nothing you're bothered. You're only treating them like a good. So it could be to work as laborers, it could be for prostitution, it could be for slavery, it could be for anything where you are demeaning a human being. Any contravention of this provision shall be an offense punishable in accordance with law. This right is available to both citizens and non-citizens. We know for aliens, as far as we know it, 15, 16, 19, 29, 30. These are the basic articles that are denied to aliens. Other than that, rest of the articles are enjoyed even by aliens also. The fundamental rights I'm talking about. It protects the individual not only against the state but also against private persons. The expression traffic in human beings include selling and buying of men, women and children like goods, moral traffic in women and children including prostitution, devadasis and slavery. Moving on. To punish these acts, the Parliament has implemented the Immoral Traffic Prevention Act 1956. The term beggar roughly means compulsory work without remuneration. It was basically a practice that was used earlier by the zamindars. Some parts of India, unfortunately, still follows this. Even if it is not there, its modern version is there, which is basically what bonded labor. Bonded means you are working for a mine or a quarry continuously for 4-5 years. All right, where maybe you have been sold to that quarry by the person has been sold to the quarry or quarry by the parents. By bond they are there. Or the father would have borrowed a sum of money, he is unable to pay it. The son or the daughter is forced to work inside a brick kiln. No payment till that money is compensated. In this regard, the Bonded Labor System Abolition Act 1976, the Minimum Wages Act 1948, the Contract Labor Act 1970, and the Equal Remuneration Act 1976 were made. In addition to beggar, the Article 23 prohibits other similar forms of forced labor like bonded labor. Article 23, an exception is there, that is, it permits the state to impose compulsory service. That is, suddenly there is a huge war breaks out. That time state can demand the people who are healthy to give compulsory services to the army, military service or social service, for which it is not bound to pay. Again, there is no discrimination supposed to be done at that time. Like the olden days and all, they used to say only Kshatriya should join the army and all. That you cannot do here. No discrimination based on caste, color, creed, sex, religion, etc. Moving on. Prohibition of employment of children in factories, etc. Article 24. It prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities like construction work or railway. But it does not prohibit their employment in any harmless or innocent work. It is very interesting to note that Australia very recently passed a law putting an age limit for the children that they cannot get into social media if they are below a certain age. Alright, so this definition will keep changing because these days what is happening is children, obviously they are acting in movies, serials, etc. These are harmless, innocent work. But somewhere Experts are telling that this can affect their psychology. Even taking part in reality shows, etc., can constantly put them under a pressure of performance, which will affect their psyche and their character development in the future. The Child Labor Prohibition and Regulation Act 1986 is the most important law in this direction. In addition, the Employment of Children Act 1938, the Factories Act 1948, the Mines Act 1952, the Merchant Shipping Act 1958, the Plantation Labor Act 1951, the Motor Transport Workers Act 1951, Apprentices Act 1961, the Beedi and Cigar Workers Act 1966, and other similar acts prohibit the employment of children below a certain age. Again, all these acts are just for your information. Go through them, more than enough. In 1996, the Supreme Court directed the establishment of Child Labor Rehabilitation Welfare Fund, in which the offending employer should deposit a fine of rupees 20,000 for each child employed by him or her. It also issued directions for the improvement of education, health, and nutrition of children. The Commission for Protection of Child Rights Act 2005 was enacted to provide for the establishment of a national commission and state commissions for protection of child rights and children's courts for providing speedy trial of offences against children or of violation of child rights. 2006, the government banned the employment of children as domestic servants or workers in business establishments like hotels, dabas, restaurants, shops, factories, resorts, spas, tea shops, etc. You know, I know, the last part what we read right there. It's maybe as law it is there, but to what extent its implementation is true. Because there is another clause is there in the child labor laws. That is, a child is not prohibited from working in his or her parents' own shop. That is, if a father or mother or together they are running a hotel business, let us say, the child may come there. The child will come there, work there a little. If somebody comes in and they'll say, he's just helping me, what is the big deal? So these days, that is what most hotel owners also do. They'll basically say, it is my relative's child, it is my family only. And in that manner, they keep ill-treating the children. Clear? Taking it further forward. It warned that anyone employing children below 14 years of age would be liable for prosecution and penal action. The Child Labor Prohibition and Regulation Amendment Act 2016 amended the Child Labor Prohibition and Regulation Act 1986. It has renamed the principal acts as the Child and Adolescent Labor Prohibition and Regulation Act 1986. Again, all these are just for your info. Moving on. Right to freedom of religion, freedom of conscience and free profession, practice and propagation of religion. Article 25. Article 25 talks about freedom of conscience. That means you have the right to think, practice any faith of your choice. Right to profess, which means what? Declaration of one's religious beliefs and faith openly and freely. That is, you can openly talk about what are the religious things that you believe in. Right to practice, performance of religious worship, rituals, ceremonies and exhibition of beliefs and ideas. Religious worship, rituals, ceremonies and exhibition of beliefs and ideas. You can practice it. Right to propagate, transmission and dissemination of one's religious beliefs to others or exposition of the tenets of one's religion, but not the right to convert. Converting somebody forcibly is considered to be what? Against the freedom of conscience. That is, whatever I want to follow, it should come out of my own volition. Free will. I should think, I should put my mind to it. If I find it attractive, I can follow it. Getting the point here? Nobody is supposed to force me or forcibly convert me from one religious belief to another, because it will violate the freedom of conscience. Either freedom to practice, either freedom to profess, that is talk about it, and propagate also. Spread the ideas. Article 25 covers religious beliefs, doctrines and religious practices, rituals. The state is permitted to regulate or restrict any economic, financial, political or other secular activity associated with religious practice, provide for social welfare and reform, or throw open Hindu religious institutions of a public character to all classes and sections of Hindus. Why specifically Hindus are being mentioned there? The reason because of the caste system. Unfortunately, even today, there are places in India where certain temples, people from the lower caste are not even allowed to enter it. Getting the point here. Years ago, I still remember in the Hindu newspaper article had come where many elderly women can be seen like crying, like it's almost like they are crying with so much of pain. And that photo had appeared. I'm not going to name from which state it was. What was the reason for their pain or anguish? When you read the news article, you will actually feel seriously. The reason for their pain or anguish was temple has been thrown open to people from the lower caste. So the elderly ladies were unable to take it. Oh my God, the temple now, look at it. Lower caste people have entered it. That was the reason for their cry or anguish. Getting the point here. So many things are there still in India socially, which we need to ostracize, and we need to bring a change to. Article 25 gives two explanations. Wearing and carrying of kirpan is to be included in the profession of the Sikh religion. The Hindus in this context include Sikhs, Jains, and Buddhists. They are also considered as part of the Hindu fold. Freedom to manage religious affairs. Article 26. Right to establish and maintain institutions for religious and charitable purposes. Right to manage own affairs in matters of religion. To own and acquire movable and immovable property. Right to administer such property in accordance with the law. That means if Article 25 talks about individual freedom when it comes to religion, Article 26 talks about the collective freedom, where you can establish and maintain an institution to manage the religious affairs. And every religious community has the right to manage their own religious affairs, and you can own and acquire movable as well as immovable property. Plus, you can administer such property as per the law. Article 26 protects collective freedom of religion. It is subject to public order, morality, and health, but not subject to other provisions relating to the fundamental rights. The Supreme Court held that a religious denomination must satisfy three conditions. It should be a collection of individuals who have a system of belief which they regard as conducive to their spiritual well-being. That is, anybody cannot come and claim that, okay, I'm going to start a religious institution. Why? Because generally religious institutions need not pay tax. Getting the point here. So it is necessary that we need to ensure, court should also see, or the government also should see, that whichever institution it is that claims itself to be religious, whether genuinely it is religious or not. That is why Supreme Court gave that condition, that is a collection of individuals who have a system of belief which they regard as conducive, which is important for their spiritual upliftment. It should have a common organization, and it should be designated by a distinctive name. Under the above criteria, the Supreme Court held that the Ramakrishna Mission and Ananda Marga are religious denominations within the Hindu religion. It also held that Aurobindo Society is not a religious denomination. It is more like a philosophical, much more not confined by religion. That would be the easier way to put it. It is not actually confined that, okay, only people of a particular religion or of a particular faith can be part and parcel of Aurobindo Society. Nothing like that. You can be from any walk of life. Clear? So that is the point. So moving on to freedom from taxation for promotion of a religion. In a nutshell, I will tell you what this means. See, basically, we can treat all the religions in the same way. But to promote one particular religion alone, you cannot actually make any policies. Just one religion alone. Getting the point here. We will see its elaboration slightly here. This comes under Article 27. The state should not spend should not spend the public money collected by way of tax for promotion or maintenance of any particular religion. For all the religions, you can promote, you can use the tax money, not for one religion alone. The taxes can be used for the promotion or maintenance of all religion. This provision prohibits only levy of a tax and not a fee. That means, let us say you have constructed a road or a specific path for a religious community to go to their holy shrine, whatever be it. So, as an entry fee, can a small amount be collected for the promotion of that particular religion or for the promotion of a particular faith? An entry fee is kept in the temple or in the mosque or maybe in the church or whatever. An entry fee is kept. Can that be done? That is absolutely possible. Why? Because that fees is going to be used by that religious community only, for the benefit of the community only. Fee is to control secular administration of religious institutions and not to promote or maintain religion. That is the point here. That fees is being collected only for that religious structure, whatever it is, that institution that is there. Just like a library. Library fees is there. Why? To help in the maintenance of the books of the library and the library's infrastructure. Just like that, fees is collected for a religion, that is fine. But if at all you're using the tax should be used for all the religions equally, not for promoting any one particular religion. Freedom from attending religious instruction. Article 28. No religious instruction shall be provided in any educational institutions wholly maintained out of state funds. That is, if any particular institution is partly funded or wholly funded by the state. Okay, that is that organization gets their money from the government. In such a scenario, you cannot give religious instructions there. You can put a general prayer, that is fine. But again, only with regard to a particular community or a particular religion, you are giving instructions there, that cannot be allowed. This provision shall not apply to an educational institution administered by the state, but established under any endowment or trust requiring imparting of religious instructions in such institution. So this law here will not apply to those educational institutions which are only managed by the state, but was initially set up under an endowment or trust with a particularly for one purpose, what? Imparting religious instruction means, then no. Article 28 will not apply there. Further, no person attending any educational institutions recognized by the state or receiving aid out of state funds shall be required to attend any religious instruction or worship in that institution without his or her consent. So, there is freedom. If you want, you can attend. If you don't want, you need not attend. That is the point here. That freedom should be there whether you want to attend or not. This was an important clause when it came to the whole UP Madrasa Act again. So in that UP Madrasa Act also, when the High Court ruled the whole Madrasa Act passed by the UP government as unconstitutional, one of the foundation clause there was this, where they told that madrasas, if they are being funded by the state, and other non-believers are there, non-believers of Islam or other non-Muslim students are there, they cannot be forced or compelled to attend the religious instructions there. Madrasa, if it is completely run by Muslim community, all right, and if at all a non-Muslim student is there, hypothetical scenario, he or she will have to listen to that instruction, listen to that prayer, attend their meeting, whatever, they'll have to do that. But madrasa is funded by the state means what? It's a different ball game. It's a different ball game altogether. Why? No religious instruction shall be provided in any educational institution wholly maintained out of state funds. You cannot force the particular student to, you have to listen to this prayer now, you have to do this now. You cannot force. Why? State is funding it. Our tax money is going into it. In case of a minor, the consent of his or her guardian is needed. Article 28 distinguishes between 4 types of educational institutions. A. institutions wholly maintained by the state, institutions administered by the state but established under any endowment or trust, institutions recognized by the state, institutions receiving aid from the state. In A, that is institutions wholly maintained by the state, religious instruction is completely prohibited, while in B, religious instruction is permitted because they are only administered by the state, but actually are established by what? An endowment or trust. C and D, religious instruction is permitted on a voluntary basis. What is C and D? 1 minute. C and D means institution either recognized by the state or institution receiving aid from the state. So there it is left to the individual whether he or she wants to attend the religious instruction or not. Clear, people? This was about it. So once again, this is my Telegram channel. Any doubts or queries that you have, you can contact me here. You can send in your PYQs also here. With that, we come to the end of the second part of fundamental rights. This chapter is really big. That is why I'm breaking it up into series, and then we will continue with the cultural and educational rights onwards in our next part, which will be the final part of the chapter number 8 on fundamental rights. Take care, people.